Thank you, everyone, for coming to the NYU Law Forum. It's great to see so many faces here. We're here to talk about Moore versus United States, a case that has the potential to remake our tax system. It has been a century since the Supreme Court struck down an element of the income tax as being unconstitutional. Since that case, Eisner v. Macomber in 1920, the Supreme Court has largely stayed out of tax, at least when it comes to constitutional boundaries, leaving it to Congress and the President to determine how to tax income. Of course, it was the Supreme Court itself that prompted the 16th Amendment to the Constitution, empowering Congress to tax income from whatever source derived. In what was somewhat of a surprise at the time, the Supreme Court in 1895, in a 5-4 decision, declared the income tax enacted at the time to be an unconstitutional direct tax. Congress then responded with the 16th Amendment, giving the power to tax income from whatever source derived back to Congress. And with the notable exception of Eisner v. Macomber, the court then left well enough alone and let Congress and the President work out Congress's ambit to tax income under the 16th Amendment and beyond, until this year, or last year. When the court took the case Moore versus United States, it took the case in the wake of proposals for fundamental reform of the income tax system, wealth taxes discussed on the 2020 campaign trail, and President Biden and Chairman Wyden of the Senate Finance Committee proposing versions of mark-to-market income tax systems that would tax changes in asset value even if assets hadn't been sold. But those measures were not enacted, and that's not before the court, at least directly. What is before the court is something different. A corporate provision in the 2017 tax law and the implications of the challenge are wide-ranging, as we'll discuss. Today, we'll explore how we got here, what the case could mean, the tenor of the oral argument in December, and the political and economic context that seems to have prompted the court to step back into this space. And we have 3 leading experts to discuss these issues. First, Chai-Ching Wong is the executive director of the Tax Law Center at NYU Law. Before starting at the Tax Law Center, Chai-Ching was senior director of economic policy for the Center on Budget and Policy Priorities, where she worked on the analysis and design of a wide range of federal tax, fiscal, and economic policy proposals. Chai-Ching has written on a wide range of federal tax and fiscal and economic policy issues, testified several times before Congress on tax issues, and appears regularly in the media. And the two of us got a chance to work on an amicus brief together on this case. Second, Eric Solomon. Eric is a partner at Ivins, Phillips, and Barker and an adjunct professor at Georgetown Law and one of the country's leading tax practitioners and policy experts. Eric has more than 40 years of tax experience in private practice at law and accounting firms and a government service at the Treasury Department and the IRS. On the private practice side, before this, he previously served as co-director of Ernst & Young's National Tax Department. On the policy side, he from 2006 to 2009 served as Assistant Secretary for Tax Policy at the Treasury Department. That is the lead tax policy role at the department, and served as primary advisor to the Secretary on legal and economic matters relating to domestic and international taxation. Eric has significant experience before that in government as well, serving in both the Clinton and George W. Bush administrations in a range of roles. He also received the Alexander Hamilton Award, the highest award for Treasury service. Catherine Rampell is one of the country's leading commentators on economics and politics. She writes a twice-weekly syndicated column for the Washington Post, which has covered this case. She is a politics and economics commentator for CNN and a special correspondent for PBS NewsHour's Making Sense series. She is also a regular guest on Marketplace and has appeared on many other radio and TV shows. Catherine frequently covers economics, public policy, politics, and immigration with a special emphasis on data-driven journalism. Among other honors, Catherine received the 2021 Online Journalism Award for commentary and the 2010 Weidenbaum Center Award for evidence-based journalism. So I'm so grateful that we have our panelists here today to discuss this consequential case. So I'm going to start off with questions for each of our panelists then have some conversation, and then would love to take questions from the audience. To kick us off, first turning to you, Chai-Ching. So I was hoping, to give some of our audience background, some of whom have more, maybe they were even required to answer a question on an exam related to this, sorry. But others will have less. So how did this case get before the court, and how can a case challenging a single corporate tax provision enacted by Republican Congress in the 2017 law potentially threaten the income tax?
Thanks, David. So great to be here. And as we'll talk about, there are many layers in which this case is pretty consequential. As you noted, we could start some 100 years ago or even before that, but I'm going to start a little bit less deeply in the past and take us back to 2016, 2017. The corporate tax system at that time said that if you were a domestic corporation making profits, you have to pay tax on those profits in the year that you make those profits. Foreign profits, however, of US controlled multinationals did not necessarily have to face that same rule. If those profits were declared as being permanently reinvested offshore, offshore profits, they didn't have to face tax until the companies declared them as having been shifted back into the States. Now, often that was just an accounting shift, not a real shift of any assets, but that was the situation. So these companies were allowed to delay and sometimes indefinitely defer facing the US tax rate on those corporate profits. And there were some, 3 trillion, 4 trillion, 2.9, something like that, in the trillions of dollars of these foreign profits sitting offshore, having never faced US corporate tax. So that's the situation we were in 2017. And Congress and President Trump enacted a new tax law that made major reforms to the international tax system. You might hear some of the acronyms from Eric or others of us later on. But really it said, we're moving to a new system. Those profits will have to face taxes in the year that they're made, just like domestic profits. There'll be a lower rate and some other details. But we've got to deal with this big stack of profits going forward. So they said that income tax that would usually, if it had been domestic profits, been paid in each year that it was earned, would face a one-time toll charge. And it would be at a very discounted rate, far below the rate on domestic profits, on foreign profits, under the past system or under the new system. So at a very deep discount. So why am I talking about large multinationals and big corporations who are the bulk of that some $3 trillion in profits, when I'm talking about this case where the petitioners are a couple called the Moores? I will try to link the things together. So in the 2000s, the petitioners, a couple, the Moores, had made some $500,000 in foreign profits from their ownership stake in an Indian company. Now, those profits were, under most definitions that were understood at the time, income that were realized by the Indian corporation in each of those years. By 2017, because of that old tax system, those profits hadn't faced tax, got to be delayed under that old system. So under the new law, the petitioners faced some tax on those past profits. And they said to the courts, and then ultimately the Supreme Court, that actually those profits should not face any tax. They were challenging it as unconstitutional. They were saying that the 16th Amendment power to lay and collect taxes on income from whatever source derived did not extend to those past profits. And they were saying that that's because those profits had not been realized, a term that we'll come back to in a number of ways. So that is the background, and it is interesting to note, and we may come back to this, that the petitioners were not really representative of the bulk of what was going on in that law. They were individual shareholders of a foreign corporation, and the bulk of the law's impact was on, the FANGs, as you might be thinking, the large multinationals that have a lot of ability to shift profits offshore. So anything you want me to add to that, David, before we start thinking back further in the past?
That sounds good to me.
Eric?
Great. Well, Eric, I'm going to tee you up for a moment, even though probably each of us could like just deliver spiels at this point about more. But nonetheless, a little bit of a question before your spiel. So one aspect of this litigation is the degree to which the Moores, both in oral argument and in their briefing, claimed that this provision that Chai-Ching just described is actually pretty unique. Actually, more than pretty unique. Unique was the way they would put it. And they say it relates to a wealth tax and mark-to-market not enacted. They say, like, these are of a family, but everything else is different. And we're not asking you to decide about any other pre-existing aspects of the income tax system. And that was like a central part of their argument. So what is your view of that claim? And what the Moore's argument, if accepted by the court, would actually mean for the tax system?
The short answer to your question is the provision that's involved, and I'm going to cite a code section, Section 965, is really not unique. What Section 965 does, and I think Chai-Ching really explained it extremely well, we converted our international tax system. Starting in 2018, we converted our international tax system. As Chai-Ching so well said, before 2018, active offshore earnings, so if you ran a car factory in a foreign subsidiary, those active earnings earned by the foreign subsidiary of, let's say, General Motors would not be subject to current US tax. And that was the rule before 2018. Before 2018, if you earned interest or royalties in a foreign subsidiary, yeah, that would be currently taxable in the United States. But active earnings of US companies earned in foreign subsidiaries was deferred. You didn't pay immediate tax. You didn't pay tax until you brought the money back. Then in 2017, a Republican Congress and the Trump administration enacted this Tax Cut and Jobs Act. And we changed our tax system to pretty much a worldwide tax system. I mean, people called it something called territorial. We won't get into the details, but it's really a worldwide tax system where active offshore earnings are generally subject to US tax currently. But the question was, okay, that was the rule going forward. Going forward, if you earn money offshore in a French subsidiary, it's going to be currently taxed in the United States. But wait a minute, that's going forward. What about the past? And as Chai-Ching described, going backwards, there was this $3 trillion sitting offshore in foreign subsidiaries of US corporations. And so what are you going to do with it? It's sitting there, and it's not taxable until it comes back. So Congress had to decide what to do with that. And they could have figured out a system where they would only tax it when it comes back, but no, Congress decided a better option was just to immediately tax it at a low rate. And that's what Congress decided to do, to tax all the offshore accumulated, previously untaxed earnings, take it all, tax it at a low rate. And so that's what Congress decided to do. And so the question you've asked me, well, okay, it's a one-time tax on accumulated, untaxed offshore earnings. Is that unique? Well, if you put it in the context of how our international tax system works, it's not unique. It's not unique because, first of all, prior to 1987, the United States taxed the owners of foreign subsidiaries on passive income currently. So if you had a US corporation that owned a foreign subsidiary and earned royalties, interest, dividends, that was currently taxable in the United States. So that's one example, and that dated back to 1962. In fact, Congress in 2017, in the Tax Cut and Jobs Act, enacted something called GILTI, the Global Intangible Tax. Global Intangible Low Tax Income. There you go. Global Intangible Low Taxed Income. And that's a tax, a current tax, on the active offshore earnings of foreign subsidiaries. So in that same act, Congress passed a law that taxed offshore earnings currently. So to say that this is unique, it's not unique at all. Subpart F is very similar. It's taxing owners of a foreign subsidiary. GILTI is taxing the owners of a foreign subsidiary. So the taxation of owners of an entity that's earning money is not unique. And then if we go to the domestic side, what about a limited partnership? In a limited partnership, you're taxing limited partners on income that they're not necessarily getting. They're being taxed on it, but they're not necessarily getting distributions of of the cash. Same for an S corporation. An S corporation, the owners of an S corporation are being taxed currently on the earnings of the S corporation, even though they might not be getting distributions. So to say that we're in a unique situation where we're imposing tax on somebody who's not getting the money, that doesn't hang together. That really doesn't hang together.
And for those of you who haven't done all your entity tax classes yet, I think Eric's just sort of ticked through entities through which some 40–50% of all business income flows. So this is not just sort of little pieces of the code that you really need to look for. This is like a really big deal in terms of the way that income is taxed across the tax code.
Exactly right. So there are many situations where the owners of a business are getting taxed on the income of the business, even though they're not getting the cash. But the plaintiffs here are arguing, oh no, you can't tax us because we don't have realization. And to them, realization is, well, we don't have the cash, we don't have the power to get the cash. And I would just say a limited partner and a limited partnership where the agreement says it's up to the general partner to decide whether they get the cash is the exact same situation. Now, there's one wrinkle here. There's one wrinkle, and the wrinkle is what Section 965 is doing, unlike these other provisions I'm talking about. These other provisions I'm talking about, it's taxation of current earnings. So when I think of subpart F or guilty or partnerships or S corporations, it's taxation of current earnings. And so the argument is, this is an outrage because you're taxing accumulated earnings. This is different, the taxpayer would argue, because you're taxing accumulated earnings. And the response to that, I scratch my head with respect to that issue, because I don't understand. So Congress can tax currently under the 16th Amendment, but if it decides it doesn't want to tax immediately, but it tax later, somehow that becomes unconstitutional, and that fails the realization requirement for the 16th Amendment. I can't, that doesn't hang together for me. So the short answer is I would say that these provisions are not unique, but I think that the plaintiffs in this case, what I speculate is they recognized that the Supreme Court, once the Supreme Court really understands what this case is about, is going to realize that if they hold for the Moors, that they're going to be threatening the validity of all sorts of parts of the Internal Revenue Code. So I think what happened is that the plaintiffs here went out of the way to argue, no, we're not trying to invalidate all sorts of other provisions of the code. We're only focusing on Section 965. And what they're really after, again, this is my own personal speculation, what they're really after is a wealth tax. They want the Supreme Court to say, realization is required. Well, a wealth tax isn't a tax on income. It's just a tax on value of property. And so the 16th Amendment doesn't only allows taxes on income. And therefore, a wealth tax would be unconstitutional. That's what I think they're really after. And then the second thing they might be after is there are various provisions in the Internal Revenue Code that tax you even though you haven't, for example, sold an asset. There are taxes on unrealized gains in the code. And so perhaps they're also interested in getting the Supreme Court to invalidate what I call mark-to-market provisions. Provisions that would tax unrealized appreciation even though it hasn't, that, for example, stock hasn't been sold yet. That's what I think what they're really after. But they're concerned that the court will see all this potential collateral damage from a broad, sweeping opinion about realization. And so what they're trying to do is say, Supreme Court, don't worry about these other situations. They are distinguishable. And the arguments they make for distinguishing them is either A, that in these other situations, there's this notion of constructive realization, that somehow the shareholders are permitted to be taxed currently under the 16th Amendment because there's constructive realization. So even though there may be a realization requirement to allow there to be an income tax under the 16th Amendment, there was realization in these other situations, constructive realization. For example, the shareholders have control and can control distributions, or in an anti-avoidance situation. So I think that's what it's really about. They're targeted at 965, but really wealth tax and taxes on mark-to-market on appreciation. But they're concerned about the collateral damage that could occur with respect to all the rest of the Internal Revenue Code. And so that's a long answer to a short question. The answer is no, that these provisions, 965 is not unique.
All right, great. So I want us to return to the issue of now what the court does, having taken the case and seeming an oral argument to begin to wrestle with this challenge, which they may not have realized when they took the case. But before we do that, Catherine, I want to turn to you to provide us with some more context in terms of how you see it. Now, Catherine, you're obviously the non-lawyer on the panel, but to give at least one piece of evidence as to why, in fact, even though for many reasons you're an expert to talk about this, this case was in fact argued through the opinion pages. As we were discussing before over lunch, the first time at least I really thought, wait a moment, I should actually focus on this case was when I saw a Wall Street Journal op-ed before the court took the case, and where there was a very concerted effort through those pages to make the case for the Moors to the court. So, Catherine, I'm curious, as a leading commentator on economic policy in the US political system and writing a lot about the tax system, where do you see this case fitting into those debates, the economic debates, and how our institutions function?
So I think about this case as part of a broader project to undermine the tax code and thereby essentially the financing of our federal government writ large. So there are a number of measures that conservative organizations and Republican politicians have taken in recent years as part of this project. The sort of the starving the beast mentality, for those of you who are familiar with that cliche that became popular, I think, in the 80s. So some of them are pretty blatant, things like literally cutting taxes, right? We've seen multi-trillion-dollar tax cuts under the last couple of Republican presidents. We've been talking about the Donald Trump helmed tax cut in 2017, but there were a couple of very large and expensive tax cuts under George W. Bush, for example. Those were very costly, not funded. But there are other things too. So right now, there is a concerted effort by Republican politicians to defund the IRS, which of course enforces our tax law. And under Democratic leadership, there had been a huge amount of funding that was newly allocated to the IRS, including for enforcement. Some of it was for customer service and IT upgrades and things like that, but a lot of it was for enforcement. Again, just enforcing the laws already on the books, which, if the money is given to the IRS, tends to bring in much more than is spent, right? Because this is the primary revenue collection agency, and different metrics, different research attempts have come up with different values for what the ROI is, but it's like somewhere between $6 and several multiples of that, at least on the margin. So so Republicans in Congress right now, basically, since they regained control of the House, and many times since then, just in the past year, have tried again and again and again with some success to claw that money back, specifically for the enforcement stuff. And every time it is shown by the Congressional Budget Office, which is this nonpartisan in-house scoring agency within the Congress, they always find that it's going to cost more money to claw back the money from the IRS. It will actually increase deficits. So some of it is about cutting taxes. Some of it is about reducing the ability to enforce the taxes that are already on taxes that are already on the books, right? And taxes that are legally owed but not being paid, whether because of confusion or deliberate noncompliance. Then there are a bunch of other things going on. I've talked with David about this in the past, but there was a previous case that basically made it harder for the IRS to write guidance. Now it's much more onerous for them to basically put out documents about how to comply with the tax code than it used to be. So things like that are subtler, haven't gotten as much attention. And now with the Moore case, this is not only about constraining the government's ability to enforce tax law, but to write it in the first place, for Congress to be able to write tax law in the first place. And so all of these things have the same thematic consequence of both reducing the resources available for the government to be able to do what the government does, whether it's the social safety net or paying for inspections, food safety inspections, or what have you. They also, most of these things, have the consequence of disproportionately benefiting deeper-pocketed individuals and corporations, right? The ones who are a little bit savvier about figuring out how to we don't say that they are dodging taxes. What's the term of our
Tax
Avoidance.
avoid?
Avoidance.
Avoidance is
Avoidance.
the, yes,
Yes,
avoidance
but
is
some
the
of them-
only
some
thing
of-
that
thank
NYU
you.
law grads do.
Thank you. Okay, I'm trying to be precise with this particular audience, but I mean some of it is outright evasion as well, and there have been a number of high-profile cases, including somebody who was recently in the White House of doing pretty blatantly fraudulent things and who had not been, enforced necessarily, had not been subject to the full power of enforcement. I'll put it that way. So, in a number of ways, this is going on. And it's not just on the tax side of things. There are other efforts to sort of sabotage the administrative state that are kind of beyond the purview of this panel, but it's things like making it easier to fire civil servants and whatnot. So this is part of a broader project, I guess is my point. And you can already see ways that this kind of effort is being pushed forward even beyond the Supreme Court. So like, for example, there is a bipartisan tax deal that was agreed to recently. It hasn't passed, but there's legislation that basically expands the child tax credit in exchange for re-upping some recently expired business side tax breaks. So both parties get a little bit of what they want, and it was paid for by essentially with an offset of phasing out another tax break that was largely fraudulently claimed, a pandemic era tax break. And a lot of us pointed out, oh, this is great. Like, not only did both parties get something that they wanted, but they've set up this precedent that if you cut taxes, and both of these things are effectively cutting taxes, the child tax credit and the business tax breaks, that they should be paid for. And either today or yesterday, the ranking Republican member on the Senate Finance Committee said, no, we don't want to set that as a precedent. Going forward, we think we should not have to pay for tax cuts. And that was his objection to this deal, that it was too fiscally responsible. So there are a number of measures along these lines that suggest the game going forward is to, again, try to essentially defund the government. And even some members of this, sort of ideological contingent who you'd think would be supportive of the Moore case, such as Paul Ryan, have warned that, like, maybe we've gone a little bit too far. Paul Ryan recently made some comments talking about the Moore case, saying, he's buddies, he respects many of the organizations that have brought the case, like Heritage, or who are in support of it, but he doesn't want the wealth tax, and he thinks great if this somehow precludes that from happening, but he's worried that a court opinion could inadvertently make unconstitutional about a third of the tax code. And that would be a bad idea. Even to Paul Ryan, that would be a bad idea. But that's where we are today.
So to pick up where Catherine left off, wanted to put a question to the panel about how the court, having accepted the case and now presumably deciding it, can plausibly avoid that kind of damage that Catherine was describing, and as they seek to potentially try to write what they think is a narrow decision. So just as like a moment of context, I think the broad takeaway from the oral argument in December was that it did not seem like a majority of the court was totally ready to jump up and say, yes, Moores, you've won, we accept your argument. Down goes the 2017 tax, and down goes a third of the tax system. But even as it didn't seem like there was a majority of the court, and maybe sort of in a more Paul Ryan-ish position, who were ready to sort of set on fire a large portion of the existing tax code, they also seemed to be trying to seek some limiting principle where they could still say, at least a majority, that, yeah, even though it's been 100 years since we, the court, have come in here, we are going to set some forms of boundaries. So I'm curious for your views about how the court, having taken this case, sort of takes an off-ramp, and what are the off-ramps that still, maybe unbeknownst to them, set on fire a significant portion of like the tax code and leads to a lot of litigation, and what are the off-ramps available to them that that doesn't?
They don't really have any convincing off-ramps. I mean, the easiest way, and the one that we wrote a brief saying that they should do, is to rule for the government that there is no, that as the tax code is recognized for a long time, there is realization here. It was just at the entity level, and that's enough for that tax to be constitutional, and they don't need to decide broader questions about whether or not there's any realization requirement at all. But to sort of take you down the rabbit hole of the argument, and I think, again, what was going on here is, as Eric said, the petitioners themselves realized that this is part of the game here. They spent large chunks of their brief and large chunks of the oral argument basically attempting but failing to disavow themselves from all of this chaos and setting on fire that we've been talking about. They don't ultimately, therefore, even fully commit to their theory because of where it would lead. They start off their brief by saying that the 16th Amendment requires realization, and not just realization, but in the hands of the taxpayer, not at the entity level. But by the end of the brief, they've conceded that realization actually has no fixed constitutional meaning, and it's just something that legislators get to decide. And they've also said that, yes, actually, Congress can look through the corporate form and attribute realized income at the business entity level to the shareholders, and that's the thing that saves all of these other parts of the tax code. So in sort of trying to thread that needle, they've tied themselves in knots, to throw in yet more metaphors, and one of the things that has been actually really hard for me when talking to sort of reporters and general interest people is to be saying, actually, no, this is not just confusing because it's a tax case. This is not just complex because of all the provisions in the code. The petitioner's argument really isn't coherent. It sort of goes in a circle, and it doesn't provide you clear ways of protecting the other parts of the tax code because they can't be distinguished from Section 965, the provision that they are saying is unconstitutional. I'll throw over to Eric next, but he mentioned constructive realization. They said that maybe saves some things. Throwing an adjective that doesn't mean anything in front of a word that doesn't mean anything, at least according to the courts and its decisions over the last century, doesn't save the concept. And they don't really give, again, any solid definition that would save these other parts of the code. So I think the fear is that although, as David was saying, the court seemed to be aware of these risks and looking for a way to avoid them, they only spent 5 minutes on any one of the risky routes to try to avoid this problem, and it's possible that they land on something that they think is effective at saving these large parts of the tax code, but don't.
Yeah, if you read the oral arguments, you see that the Supreme Court really senses that there's a risk here, that there's potential for invalidating large parts of the code. And they are looking for an off-ramp. I see two off-ramps. The first one is one that Les Samuels has said what they should do is say, hey, we gave cert here, we granted cert here, but we shouldn't have, and just send the case back. And a recent tax case that was done. So in the last year, there was another tax case which was argued, and then the Supreme Court said we improvidently granted cert. Another possibility is that exactly what Chai-Ching was saying. Hey, there was realization here. There was realization. It was in the foreign corporation. It earned money, so there was realization. And so we don't have to decide the question of whether or not the Constitution in the 16th Amendment to allow income tax requires realization. We don't have to answer the question. It was realized. And all these other provisions basically work that way. I mean, subpart F is presumably constitutional. The taxpayer admitted that. Guilty presumably is constitutional. That income is earned. And so the only real questions in this case, and I think that the court could say we don't have to decide whether there's a realization requirement in the 16th Amendment in order to have an income tax. The only real question in this case, and the court was sort of heading in this direction, are due process questions. That is to say, which is not a 16th Amendment question of whether or not the 16th Amendment allows a tax on the income. The only question is, well, when is it appropriate to tax owners of an entity on the income of the entity? When is it appropriate to attribute the income up? And a question of due process, well, the law over the years has developed that as long as it's reasonable, there's a reasonable reason for doing this, that's okay. So that's one due process question. The second due process question is retroactivity. And again, there's a history of cases where as long as there's a reasonable basis for it, you can be retroactive. So in my view, that's how they could, if they don't send the case back and say that cert was improperly granted, they say, look, we don't have to answer the constitutional question. We have realization here. The only question is attribution. We think attribution is fine. We have 10% shareholders, which is the traditional way we've taxed shareholders of foreign entities. And therefore due process and retroactivity is not a problem under due process either. And that's how they can decide the case. And if I had to bet, I think I'm more likely than not cautious. You know, I'm
Folks
very
would know
cautious.
that's a term of art in the
That's a tax
tax
term of
world.
art.
The question is, what does your opinion letter say?
Exactly. I've started taking, you know, in my life, I answer all questions on that range.
My tax opinion
Most of them
letter
are at
standards.
50.1%, and this is another one of them. So, but that's, I think, an off-ramp that they could take. They could just say, we have realization, we don't have to decide the constitutional question, attribution is okay here. But then what we got to do is we got to, if that is what they do, even with some conservative justices, we got to read the concurrences and we got to read the dissents, because that's where there may be a lot of other interesting stuff to read, where the judges are trying to influence the next case. And the next case might be about a wealth tax, if a wealth tax is enacted, or about a mark-to-market tax. And so reading the concurrences or the dissents might be very revealing, because I think what the next case might be, even if they don't decide this, you know, however they decide this case, and if they decide against the Moors, well, we can think that of the categories of cases we might see. Well, here we're seeing a tax on income. Then we might see a case on mark-to-market. And if there ever were a wealth tax, we might see a case on that. So that's what I think. They may be able to resolve this case, resolve it for the government, but nevertheless leave the door open, as courts generally do. They only answer the question before them, leave the door open to decide other cases on these other situations.
Well, do they always only answer the question before them? But moving.
That's why I say you got to read the concurrences and the dissents.
So to pick up there, to a number of what a number of you have said, to the degree we were able to guess, you know, why the court took this case to begin with, which they clearly were struggling with at oral argument. And maybe they end up just saying, well, we shouldn't have taken it. But there was a part of the cert petition where they're just very explicit. They say, you should take this case because of wealth taxes and mark-to-market. Senator Warren has proposed a wealth tax. Biden and Wyden have proposed mark-to-market taxes. You should take the case. So we've now described all the ways in which it turns out they took a case that was about more than that. But I'm curious, now that we've heard this oral argument, and also the government and the Moors, obviously, counsels going back and forth, what do you see as the status of those reforms when it comes to the court, what we learned from the oral argument? And then, Catherine, curious for your perspective, because to the degree this ends up being about those tools versus the third of the tax system that they could accidentally set on fire, what do you think of the role is of such reforms, you know, looking ahead in trying to get additional revenue for the government? So, you know, we could start, maybe Catherine, since, you know, maybe start with you. I'm curious for your perspective on how much being able to change a realization rule, do some form of mark-to-market reforms, or even a wealth tax, is something where you see that kind of flexibility for Congress is important or not. And then curious on the legal side, how you would see those reforms in the wake of the Supreme Court argument.
So I think that there's a lot of energy on the left wing of the Democratic Party for a wealth tax. It was a big issue in the 2020 Democratic primary. I'm trying to remember if it was an issue in 2016. I don't think it was as much. But it definitely was in 2020. And I think it's a good applause line, certainly for a lot of politicians. I think it's very unlikely that they have the votes for it, because of a combination of, even before this case, concern about its constitutionality, or at least how this particular court would view its constitutionality, as well as various other concerns that bog down basically any increase in taxes. But the Democratic Party in general has sort of convinced itself that the only people who need to have their taxes raised are the billionaires, and carving out the rest of the population. Biden himself he hasn't said billionaires, but he said, and again, David and I have talked about this in different contexts, but Biden himself has said, he's not going to raise taxes on anyone making under $400,000 a year, which is the bottom 95% of the population. So I think that there's a lot of sort of popular energy behind anything that sounds like it's getting the very tippy top of the income distribution. Whether that actually happens, I think, is unlikely. There are better tools out there, in my view, having talked with tax attorneys, tax professors, and tax economists about how to raise revenue, including from the very wealthy that would be shy of a wealth tax. Things like, just a retrospective capital gains tax, where you sort of impute the deferral benefit of holding on to whatever your assets are until you die, for example, or until there's some sort of transaction. So there are other things that my understanding, and others on the panel can correct me if I'm wrong, would probably face less risk from litigation, that would kind of achieve the same thing, but maybe you disagree, but they would probably be less vulnerable anyway to a court risk, but they don't bring the money right away, especially if we're talking about only until the asset is sold, whereas a wealth tax would be immediate, presumably, but probably could be gamed, so maybe not. In any event, there are plenty of tools that Congress could use if they had the willpower to do so, and whether or not this court rules, I'm not sure that they have the willpower to do so.
And what Catherine was saying, some of you may not know my particular background, but I was in the Biden administration, so
we argued about this. So.
I was sometimes on the receiving end of Catherine's questions. But now to the legal side. I will say, just to decide, because I have a hard time not editorializing a bit. Important to note that one of the reforms that Catherine was discussing, in terms of the way you get at this kind of built-up income, would be to focus at the point of death. Mm-hmm. When presumably the court would be like, oh, it seems realization, it's a transfer, we've generally upheld all that stuff, fine. We could go back and forth on substance. We could definitely go back and forth on politics. Obviously, the politics of taxation at death has been challenging, which has sometimes led to proposals that try to focus a little less there, but to get at something similar. So now, on the legal side,
I would also add, by the way, that a lot of these debates are also distorted by how the Congressional Budget Office, the agency that I was talking about before, that determines how much a bill costs or raises, what time frame that they use, right? So they always look at a 10-year time frame, and that in turn gets factored into how many votes you need basically to move forward certain kinds of bills. It's complicated and arcane and frankly pretty stupid, but that's how our government works. And so some of these things may also be less politically viable because they raise money after 10 years. So they raise a lot of money after 10 years, but not as much in the initial 10-year window, whereas a wealth tax, in theory, would raise it right away.
So now to the legal viability. If you're sitting over a treasury and actually are trying to put pen to paper, how would you assess risks of either fundamental proposals or something that's more incremental? On mark-to-market, there have been a number of more incremental versions that were put on the table, including by Republicans. I remember Dave Camp was thinking of expanding mark-to-market when it came to derivatives. So whether more fundamental or more incremental, how would you view this in the wake of the argument?
I'm going to take a different question.
Sure.
I'm going to go back to how it got to court, because I do think it is actually, it goes into this assessment going forward about the risks to tax policy making as an arena for Congress and the president that one would have thought was, for Congress and the president previously, but is more and more no longer the case. This had none of the traditional indicia of like being a Supreme Court case, as you said. Like there wasn't a circuit split. This was like not getting a ton of attention. And the root was a bunch of Wall Street Journal opinion editorials framing this as being about a wealth tax. And I think it is notable that the appeal to the court was to try to frame this as one of the most partisan policy issues that is there. And that is an appeal to a court that at least the petitioners and their supporters and the Wall Street Journal opinion editorial page thought that that partisan appeal was the way into court. And they were right. So now, as the court has discovered through briefing and oral arguments, the case is about a lot more than that, and it's complicated. And in fact, it's not really neatly falling down around partisan lines. We have big tax cut advocates like former Speaker Paul Ryan saying this isn't the way. You have conservative economists, conservative former lawmakers, staff weighing in with the court saying, again, we would like to cut taxes and we think wealth taxes are bad policy and unconstitutional, but this is not the case. So the fact that it's even there changes, I think, the calculus going forward about what gets into court and what gets serious consideration as being something that is constitutionally suspect, or as I know Eric has feelings about, is suspect from a procedural administrative law perspective or some other rationale. And I think we have to all be sort of baking in much more seriously the courts weighing in and what has previously been a zone of congressional sort of policymaking and discretion. One other thing that just sort of connects briefly to Catherine's notes around the sort of the valences on this and why this is not a case, not necessarily the case. Turns out that generally raising taxes on corporations is very popular. And one of the other problems that the court is going to face as a somewhat small p political body is that if they decide this is the way to stop a wealth tax, they will be doing it by potentially having to pull down a provision of law that raised $300 billion from corporations and therefore opens the door for them to go back and get those tax refunds or even more. So the complications abound, but they are ones that I think we who think about these policy proposals are going to have to think about more and more.
I want to read from the transcript.
Go for it.
Yeah, I've started reading transcripts, and it's really revealing. It's like a law school class because the justices are very smart people, and they ask very good questions. And so here's. I'm just going to read from the transcript.
Though they did take the case.
Justice Kavanaugh asked, okay, I think this question's an easy one, but I want to make sure. If there were a federal tax on the value of someone's property, you agree that's a direct tax, and that's a direct tax would have to be apportioned under the Constitution. Or on the value of someone's holdings, you agree that's a direct tax that would have to be apportioned, correct or not? So the question is whether or not a tax on the value of property is constitutional. That's basically what the question is. Yep. And if it's a direct tax, then the 16th Amendment wouldn't cover it. It wouldn't be allowed under the 16th Amendment. So just to tell you what that reference to a direct tax means. If it's a direct tax, it's not safe under the 16th Amendment and would have to be apportioned according to population under Article 1 of the Constitution. So that's what Justice Kavanaugh is asking. And here's the response from the Solicitor General, who I have to say was incredibly impressive. To master tax law, I was so very impressed. But here's the response. That's a tax on property because it's looking at the total value of the asset and it's doing it at a particular point in time. That's totally different from an income tax, where you're taxing the increment of gain over time and generally only doing it one time with any future tax looking to a new investment of gain over a new period of time. So to me, that is a statement by at least the Solicitor General that there is a significant question whether or not a a tax on value, a wealth tax would be constitutional. So I just wanted to point out that it is recognized that there is a significant question whether a wealth tax would be constitutional, would be allowed under the 16th Amendment. Even the Solicitor General said that. Now, in various other parts of the argument, there were concerns by the justices about, well, what about a tax on appreciation in stock? And that one, the Solicitor General was, I would say, much more positive. That is to say, she said that the government would litigate that case. It's not an easy case, but that the government would litigate that case, that's okay. So I wanted to respond to your question about some of the considerations that Congress would have to take into account.
I want to hear what David would do. You've left, policy making and have come back to set your class's hard exam questions.
How about a value-added tax?
How would you be sort of?
How about a value-added tax?
You could go.
I mean, every other country in the world has a value-added tax. Perhaps that's where we should be going with an additional surtax, income tax surtax for high earners. I mean, that presumably would be constitutional. So I don't want to put words in your mouth, but I just want to suggest another way to go.
Now the tables have been turned on the moderator.
Exactly.
Look, I do think there are good reasons to actually start, given the way our political system has worked, with tools that affect the top. I don't think it is mere political positioning that is like counterproductive, but I think that even as we are likely to need more revenue than is certainly available up there, that coming up with reforms that can plausibly change, and I know we could have long discussions about how this rate was calculated, but the calculation from Danny Yeagan and Greg Leisterson, that top 400 average rate of 10% on income, 12% if you include inflation and so on, can be changed, are real and substantive discussions to have. I agree with Catherine that chances are a wealth tax route seems less likely. Is some version of a mark-to-market, could it have been more likely in some version of Congress? Possible. And again, there are more incremental versions of that and more fundamental versions. As Dave Camp was playing with, admittedly much more incremental, but an incremental version of that. So I hear you on the value-added tax, and certainly value-added tax is a way of getting at the top. But it doesn't strike me that it's unreasonable to think that given our system that, we do know how to tax people below the 95th percentile. It's not like we don't have tools to do it even without a value-added tax. But there's a question of what tools do we have to get at the very top? And there's a limited list: realization of death, trying to pull that forward, and so on. And I think having more flexibility to pursue more of those routes makes a lot of sense given how challenging it is to actually enact. So now I've editorialized. That was not in my role as moderator.
Just one sentence. Just the question is, when you do all the revenue estimating, if you just focus on the very top, is that going to raise enough revenue for the challenges that we have going forward?
No. No. But no. The answer is no. But that doesn't mean it shouldn't be a part of the solution.
Understood.
I think I saw some calculation that it was, if you did 100% wealth tax on, I'm trying to remember if it was billionaires and 100 millionaires, something like that, and you assume no behavioral changes, right? Nobody's avoiding or evading, that would pay for about 1 year's worth of government. So it's not enough.
So I want to leave enough time for some audience questions at the end, but I have one last question for the panel. And maybe it's because I see some faces from my legislation regulatory state class who I encourage to come. And so since they, at least some people here are in such classes, I wanted to say the word Chevron. Oh no. We haven't learned it yet in LRS. But the Supreme Court heard an argument in that case last week. I'm sure there will be a forum on it, so this is not the place we're going to fully dive in to that case and its implications. But I want to discuss what it means maybe in the tax system and in a broader context, relating it to more. There are a combination of cases fall of Chevron, Moore, and so on, where we're seeing increasing challenges to the administration of the tax system and also the legislation of the tax system. And would love your thoughts on the implications and what you see as sort of the broader the broader legal shifts here, and how you would relate the oral argument in the case challenging Chevron last week to Moore and other developments.
Do you want to go first or me? Go first.
It's a great class to be taking, because these issues are coming for us all across.
You should be. You're required, but it's good.
No, but pay attention. It's coming. This is part of the sort of the broader set of risks and threats that I think we all need to be sort of thinking about, both in terms of policymaking and tax administration. We have our own, at the Tax Law Centre, running internal lists of these different lines of cases, and they go everywhere from the core of what standard of review, as in, the Chevron cases, through to questions like, does the requirement to fill in an information return so that the IRS can know basic details that it requires to administer the tax system, does that impinge on your free speech and association rights? There are lines and lines and lines of these cases happening all across the tax code and the tax system, and all across administrative and constitutional law and the Administrative Procedures Act and half a dozen other relevant statutes besides. And that is also part of, I think, the reason why Moore made it to the Supreme Court, because the folks that are mounting these cases are able to play, they have the resources to play the sort of the litigation lottery. And the government, with its under-resourced staff at every level, including in DOJ and some of these other key places, can't treat every single one of these lines of cases with the seriousness that it might necessarily deserve. And Les Samuels, former Assistant Secretary that Eric mentioned before, has done some great work looking at some of the factual defects on the record, and some of us have pointed out arguments that could have been made in the lower courts potentially. But the reality is, when there are like dozens of these cases across the Constitution and administrative law running through the courts and attacking different parts of the system, it's very difficult to understand which one of them is going to make it to the Supreme Court, which one of them is really going to have these implications that could pop up. And it just sort of underscores the need to develop your own understanding and judgment of that range of considerations when it comes to practicing in tax, making tax policy, administering the tax code.
There are many challenges currently to various things that are done by the government, and what I find so very interesting about this is like constitutional law for tax lawyers. And we're in the Moore case, we're seeing what's the role of Congress, what laws can Congress pass, and then we're seeing, you mentioned Chevron, which is, what's the scope of authority of the agencies to write rules, and are the agencies stepping beyond their proper authority when they write certain regulations, for example, in environmental protection. And that's a question of separation of powers between the agencies, between the executive branch and Congress, the legislative branch. And the question is, how much power does the executive branch, and is it usurping the power of Congress? That's implicated here. Outside the Constitution, we have the Administrative Procedure Act. There are all sorts of challenges that the IRS and Treasury are not following proper procedures in promulgating regulations. And there are many, many cases about that. That's not strictly constitutional. That's the Administrative Procedure Act. That was the very first course I took in law school. I couldn't understand why I had to take that course. And then I realized my entire life was administrative law, because I worked for the government for 15 years writing regulations. And I have to say that there's much more attention now in the government about what the scope of authority is, because when I was in the government, we generally believed that under the Internal Revenue Code, we've been given general grants of authority under 7805B, and in many areas specific grants of authority. But now the pendulum seems to be obviously swinging against that. And then also lurking in the background is the major questions doctrine, which was raised in the West Virginia versus EPA maybe it is not going to affect tax cases, but the question is whether or not something's so important that Congress couldn't possibly have delegated it. So yes, we are going to see increasing issues in this area. And we're going to have to pay, obviously, we're going to have to pay attention to that. And, each of us is going to have to, in my view, we also have to, reach our own views. But I do say, in some ways I say, look, taxpayers are permitted to challenge these things. That's the right that they have to challenge these things. And the Constitution says what it says. And so the 16th Amendment has to be interpreted. Our gut reaction isn't necessarily always the right answer. Of the framers of the 16th Amendment and through our history, we have rules, and the Constitution are the rules, and we have to interpret them. And we have to deal with that and deal with it directly.
Great. So wanted to leave time for questions from the audience. Questions? Less and less, if you don't mind going to a mic.
So thank you. This has really been quite illuminating and helpful to try to understand. I hope the group here, has gotten a lot out of this. And I would say a couple of things. One, in talking about the Chevron case, and Eric and I had to sign regulations when we were assistant secretaries of the Treasury, and we kind of keep track of our regulations and are they going to hold up? And I was just thinking, there's one sentence in the Internal Revenue Code that talks about, gives authority to the Treasury to write consolidated return regulations that go for pages and pages. And I signed a lot of those regulations. And I think the consequence of Chevron is it will blow up the consolidated return regulations, because I don't see how Congress can give authority to Treasury to write such extensive regulations.
Yeah, my response to that is that's a specific delegation. And Congress didn't do anything in that area. So I would say that one is probably, perhaps, safer than others.
Is it a major question?
Yeah. But I would just like to say, because one of the things in your and Chai-Ching kind of alluded to this, was kind of the ethical aspects of this, because the Moore case has kind of the markings of a manufactured case. And I think from the Supreme Court's point of view in maintaining their integrity, they really have to think very hard about whether they want to decide this case. And also what was kind of implicit is in a lot of the conversation, just at least from my perspective, is when the Supreme Court deals with tax cases, they inevitably have, not 100%, but a lot of the times there's a lot of collateral damage because they don't really understand it very well. And I think that's a serious question in this case. And I would say, Eric, they asked some good questions, and what concerns me is now they think they really know about it.
But I do think the amicus briefs, there were a lot of amicus briefs in this case, and for the government. So I am hopeful that the Supreme Court has been alerted to the potential collateral damage in this case. So the amicus briefs, I think, did really serve a very good purpose in that regard.
On the manufactured case point, one thing I don't think came up was that apparently a bunch of the facts in the case were wrong. Like the petitioners claimed that they had no control over the company, even though it was a married couple. The husband had served on the board for many years. And like he said, we just gave this money over and somebody else controlled the whole thing. And then it turned out that was not the case. I don't know that it has any material bearing on the arguments that they're making, but there are a bunch of kind of dodgy details.
On that front, I will say, and it goes to what Chai-Ching was saying about the challenge of the government litigating across the board. Most of those details came out after the court had already taken cert, as certain lawyers, including Wes and others, dug in. Members of New York Bar, et cetera, really dug in a way that a thin government, a government that's stretched has trouble doing beforehand. And then that leads to really hard strategic questions once you're at the court and they've already taken the case. What do you do about the factual record that turns out to have been flawed but only figured out later? But it goes again to some of the challenges of the government litigating in so many different areas.
And again, to sort of, although we have sort of hindsight now, I don't know that I would have allocated that extra time or effort like in the lower courts and put the like absolute A team on this case all the way through, because, as we all said, Wall Street Journal upend was like the first time that we took the fact that they were going to try and revisit this sort of, to us, 100 years of settled law seriously.
I will say the first time I saw it was a Yale law student's student note. FYI, for those of you thinking of writing a student note, I remember soon after the law, there was a student note saying that this tax is unconstitutional. And I remember thinking, well, that's crazy. No one thought about that. Like, I mean, literally, you talk to people who wrote the 2017 law, they're like, we didn't even think about that. But that was the first time it came to my mind, I was like, I wonder if they're going to litigate that. And then it went from there. Yeah. And why don't you go to the mic?
Hi. So it sounds like there are some very potentially dire consequences of this, like 1/3 of the tax code being sort of wiped out. So it's clear, there's a potential to open the floodgates. My question in a broad sense is who will drown first and who is able to throw them a buoy?
Yeah.
I'm optimistic that this is not going to happen. Now, I may be a fool, but I'm optimistic that the Supreme Court will see that there was realization in this case and that this 965 is okay. Now, there may be future cases, but I'm not ready to conclude that the world is going to end here.
Yeah.
So I just wanted to start by posing that. I think the Supreme Court realizes what the potential consequences are.
And if they don't, or if they don't do what they think they're doing, I don't think it's, a third goes away immediately. It's opening the floodgates to litigation that will spend a long time with a lot of provisions of the code and tax administration under a cloud of uncertainty until it all sort of shakes out. So to your point about who gets hurt in that circumstance, there were briefs from a couple of different small business organizations pointing to the fact that while some of the very biggest companies that most directly potentially benefit from 965 being pulled down have the ability to sort of plan and weather that kind of uncertainty, the smaller businesses that might be impacted by other parts of entity taxation being disrupted can't to the same extent.
Yeah, let me just respond. Okay, so this is about the Moors. They're individuals who are claiming this is unconstitutional. And so does that mean that this is unconstitutional if the shareholders are corporations? And so that might be the next case. So someone comes in, big corporation comes in for a refund, and they say, the Moors won, we should win. And so they litigate the next case. Well, they're not necessarily going to win because the government would put up a fight. And even though the Supreme Court might have held for the Moors for individuals, you could argue that a tax on a corporation is constitutional because it's a, quote, excise tax. And under the history of the Supreme Court, excise taxes are okay. So this goes to Chai-Ching's point. We're going to end up with, even if the Moors win, we'll end up a whole lot of litigation. And so it'll play out. But as I said to the beginning, I don't know, I'm an optimist, I still think.
And
I'm an institutionalist and I'm an optimist. So putting them together, I'm hopeful that we all won't go down the...
One side note, I
down
will
the
say, depending on how they frame the decision, it'll be
Absolutely.
like the question around future litigation will be important. Like right now, there's a major tobacco company with, I believe the argument has temporarily stayed because they're waiting for more, which has argued that the way the IRS is applying a reg or a provision to them is unconstitutional, which is sort of unique. Like this is not something a major corporation represented by Skadden and so on would have argued 10, 20 years ago. And the amount of that kind of litigation depends a lot on how the court frames this. So I saw, I think, another question.
But you're right, exactly what they say, even if they hold for the government, exactly what they say is going to be very important.
Did I see another question? Oh, great.
There was one over here.
All right, great. Yeah.
So what I see happening here is that federal taxation is becoming a lot more like state taxation. State taxation, there are all these constitutional constraints. There's the Commerce Clause, the Privileged Immunities Clause, the Due Process Clause. And if you're going to be a capable state tax policy maker, you've got to, your first question has got to be, what are the constraints that are being imposed externally on what I can do. And then you have various ways of working around them. And that's, if Eric's right, that's what we're moving into in federal tax policy. Typically, federal tax policy experts don't think about the Constitution. It's an afterthought. I mean, I remember when I was on the congressional staff, it was 1980, they're doing the windfall profit tax, and we had an exemption for Alaskan oil. And Don Lubick, one of your predecessors, comes into the drafting session one afternoon after lunch. He's just had lunch with his constitutional law professor. Says this whole thing's unconstitutional because this exemption for Alaskan oil violates the constitutional requirement that state excise taxes have to be uniform. And so we monkeyed with the draft to try to fix that problem. I think we created an exemption for Mount Washington to make it more uniform. And that case went to the Supreme Court, and the government won. But that's what federal tax policy looks like, where it looks like it's headed. You have to, as your first step, think about what the constitutional constraints are and what you're trying to accomplish, and then try to manage that.
But we do live under rules, and then they are the Constitution first and foremost, and so we have to know what those rules are and follow them. So I completely agree with you. And then, Congress passes laws, and we have to abide by those laws, whatever they mean. So as a rule of law, these are issues that we have to, as I said, that we have to address.
Though there is a question, as we live under rules, who decides?
Absolutely.
And whether certain questions are better negotiated between the political branches, Congress and the president, versus the Supreme Court deciding on the ambit.
And it's all these are the separation of powers issues.
That
Exactly
seems like
right.
a
Who makes
core
these
question.
calls?
And I think we were talking with Catherine before, I mean, as she looks across economic policy making, questions like the Federal Reserve and various other parts of the economic regulatory apparatus. This is not unique to tax.
So we may have time for one more question before we wrap up. And we've got 2 minutes, but we'll take full advantage. I'll be quick.
So just like kind of practically speaking on like the international level, do you think a more decision for one way or the other would have any, or to what degree of ramifications would be for perhaps like the OECD, like global minimum tax? Because it seems to me that if it were, decided that unconstitutional, the US wouldn't be able to kind of do that at all.
No, that's a great question. I mean, we're sitting here talking about U.S. domestic taxation, domestic international taxation, U.S. taxation of cross-border activities. But going on all around the world is revisiting all of these questions because multinational corporations in certain situations are move their activities to low-tax countries. So all this is being considered at a global level. And some of the solutions that are in play at the OECD are situations where you would have the owner of an entity in another country taxed. And so it raises some of the same issues, some of the exact same issues. Can you, under whatever the nation's laws are, we have our Constitution, other countries have different rules, but can you impose tax on the owners of an entity that's not in your country? So yes, those questions are very much implicated in the OECD. The thing is, we haven't gotten there yet. We're still struggling with our own. But yeah, that very similar systems that the OECD in their Pillar 2 approach is to tax the owners of entities that are in another country. So it does raise similar issues. The thing is, other countries might not have the constraints that we have in our Constitution, which sets certain boundaries and limitations.
So with that, I wanted to thank our panelists for joining us today and thank all of you for coming.